morning. Thank you all for being here today. My name is Paula Hands. I am the Public Information Officer for the Douglas County School District. We appreciate everyone coming by today. The agenda you have in your hands, we're going to go in a little bit different order, so I will be introducing each speaker before they begin. We're going to start today with Kevin Larson, Douglas County School District Board of Education President.
While we're disappointed in the court's decision today, we are not surprised. We have always believed that the ultimate legality of our choice scholarship program would be decided by the federal courts under the United States Constitution. This could very well be simply a case of delayed gratification. While Douglas County and Colorado kids may have to wait just a little bit longer to get their full access to choice, ultimately, we believe this will pave the way for all U.S. students to be free of the yoke of the Blaine Amendment and to exercise their free choice in educational opportunities.
Our next speaker is Craig Richardson, Douglas County School District Board of Education Director.
Good morning. As President Larson just said, this could well be a case of delayed gratification. But pending that, we intend to move out expeditiously on at least two fronts. Our legal team will take a careful and thoughtful and lawyerly look at the decision that was entered by the Colorado Supreme Court today. And we will evaluate the possibility of seeking a writ of certiorari from the United States Supreme Court. There is reason to believe that the United States Supreme Court will take an interest in today's decision. 37 states have Blaine Amendments. Blaine Amendments were a feature of the constitutions of many states in the latter part of the 19th century, as Secretary Blaine insisted on the joinder of those amendments to various state constitutions as a condition of statehood. In the teens of the 20th century, the Ku Klux Klan was successful in getting Blaine Amendments adopted in the South. And so 37 states have what we believe on their constitutions, on their books, an amendment that reflects a very ugly period of American history in which Catholics and Jews and immigrants were targeted by a nativist culture, a culture of hate that precluded many people from access to public education benefits. We believe that is a question that is ripe for the Equal Protection Clause of the 14th Amendment to the United States Constitution and is ripe for the Free Exercise Clause of the First Amendment to the United States Constitution. And we will evaluate those questions and consider seeking the assistance of the United States Supreme Court in answering those questions. Pending that, we will move out in every possible way we can in ways that are fully compliant with today's decision, with our choice scholarship program. We will not wait. We are undaunted. We will proceed in ways that create more choices for Douglas County students, more freedom for Douglas County households, and more competition for all schools, because we believe that competition makes all schools better. It makes all schools produce at more highly qualitative and effective rates. And so those commitments, those views about how to organize the delivery of educational services in this state and in this county are not daunted by today's ruling. We will proceed deliberately, thoughtfully, lawfully, in ways that make sense for Douglas County families. I'd like to introduce one of the lawyers who was central in representing the district in these proceedings. He, along with Jim Lyons of the Lewis Roca Rothgerber firm, are lawyers to whom we owe a tremendous debt of gratitude for their professionalism, their excellence, their thoughtfulness, and their high-quality representation of the district in these proceedings. It's important at moments like these also to recognize the professionalism of our opponents. Mr. McCarthy in particular was at all times a professional lawyer who represented his client zealously and with civility. And we want to honor that, and we respect that. We will see as the clash of views continues in the courts what emerges. But the beauty of our judicial system is that from that clash, the truth emerges. And we believe the truth remains to be discovered. Mr. Hall.
Thank you. Again, Eric Hall from Lewis Roker Rothgerber. One of the points that I wanted to bring out is just a question about what this decision we got today means, because the plurality decision held that there was no standing, and then it found a violation of one of the provisions of the Colorado Constitution. The concurrence by Justice Marquez focused only on standing and found that there was standing, and expressly did not find a violation of any constitutional provision. In fact, didn't reach any constitutional provisions. Well, it wasn't really a dissent. Justice Ide's opinion was a concurrence in part and a dissent in part, and there, Justice Ide, for 3 other justices, agreed with the plurality on standing, so there are 6 votes that the plaintiffs did not have standing, but then disagreed on the constitutional provisions. So there's a procedural question which we need to look into very carefully about what this decision actually means, given the 3-1-3 split. And that's one thing that we're going to be looking into very carefully, so that we can move forward with Douglas County on the basis of the law and the impact of this decision. Thank you.
And our final speaker today is Sharcy Russell with Great Choice, Douglas County.
Good morning. My name is Sharcy Russell, and I represent a parent and citizens group called Great Choice, Douglas County. And we have waited long and hard for this decision, and we are disappointed today. However, as our board and attorneys have stated for Douglas County, we look forward to future developments. I have a prepared statement to read for you. Great Choice Douglas County is a 501c3 organization supporting school choice. We are very disappointed in today's decision by the Colorado Supreme Court, revealing the Colorado Court of Appeals February 2013 ruling in the Douglas County School District Scholarship Choice Program. This decision, while affirming plaintiffs' lack of standing to challenge the program, nevertheless considered whether the CSP violates Article 9, Section 7 of the Colorado Constitution, also known as the Anti-Catholic Blaine Amendment. The majority found that the program constitutes aid to religious institutions, while 3 justices dissented. Justice I may have noted her dissent in that the plurality's approach is directly contrary to the wealth of the United States Supreme Court precedent. That the aid in question was extended to support students, not institutions, and that by that logic, the programs at issue in Americans United, Zelman, and others would be swept aside. The Douglas County School District may now ask the Supreme Court for review. In our view, it would be in the best interest of our Colorado families, so that the wealth of precedent will finally provide parents affordable and needed educational choice. Thank you.
We'll now open it up for any questions you may have.
The district compared itself to an Ohio voucher program that was upheld by the U.S. Supreme Court in 2002. That one said that the schools could not discriminate based on religion. This program, according to today's court, says that the private schools involved in the program, the admission standards, they don't have to make any changes. They said that that's the major difference between that one and the voucher program in Ohio in 2002. Is there any thought to just rewriting the voucher program instead of continuing with the legal battle?
They're not mutually exclusive. Obviously, you're referring to the Zelman decision.
Yes.
Our program was modeled on Zelman. So the reason that the ACLU and the Americans for Separation of Church and State did not bring an action under the U.S. Constitution is that they knew that we were constitutional under the First Amendment, because we modeled our program after Zelman. They were therefore forced to bring a theory under the Blaine Amendments, which obviously has such an ugly history and presents difficulties for them, and they're now going to experience those difficulties based on today's order. But we will adopt modifications to our choice scholarship program and proceed expeditiously in ways that are compliant with the court's order. This is a board that will be compliant with the law. We will comply with the Colorado Supreme Court's decision. We are committed to that. We owe the Court that. And so we'll carefully review their decision, and if there are ways of proceeding immediately that are compliant, we will do that, even as we consider bringing the United States Supreme Court into the picture. They're not mutually exclusive.
Can you talk a little bit more about how you would be proceeding with the program in compliance with the ruling, or is that something you're still trying to figure out?
You know, I think it would be premature to address how to do that until we have carefully reviewed the court's decision. Obviously, it was announced hours ago, and in honor to the court, we want to be very, very careful and thoughtful in reviewing that decision and making sure that if we were to proceed, we are proceeding in a way that gives effect to the court's will.
When you say immediately, do you mean as early as this fall?
Exactly.
What's been the total cost for legal fees, and can you break down what the district has spent and private funding?
We have spent over $1 million, I think maybe $1.2 million. I don't have the precise figure in front of me, all of which have been donated from private sources. The district has not spent any money on legal fees in this action. It remains our goal not to use district resources for the lawyering of this matter, including forthcoming proceedings in the United States Supreme Court.
And you thought how much it would cost to take it to the Supreme Court?
You know, we don't know what the cost is. It's never an inexpensive proposition, obviously, when you invoke the assistance of the United States Supreme Court. Particularly also, we will be having the assistance of the top legal minds in the United States in this matter. Gibson, Dunn & Crutcher and Lewis, Rocha, Rothgerber are both firms of very, very high quality, and we will want to have access to the talent of both of those firms in bringing the very best possible question for the U.S. Supreme Court to consider.
What would you tell parents about the opening street?
Just what I said today. We're going to have a normal school opening. It's going to be just like school openings have been in August every year. We're looking forward to having a fantastic academic year in Douglas County. The only question as to what we do in August will be if we can proceed with the choice scholarship program in ways that are compliant with the court's order. But other than that, it will be a ho-hum start to another fantastic academic year.
Are there students already lined up for the choice program if you find a way to proceed, or would they have to apply in the next month?
We had 500 students who won the lottery to participate in the choice scholarship program. Obviously, that didn't get very far because the trial court back in 2001 immediately enjoined our going forward with the program. And so ultimately, of course, later the Colorado Court of Appeals took our view of the Colorado Constitution and reversed the trial court. And today's court decision by the Colorado Supreme Court, we think, will evaluate that reverses the Court of Appeals. So if we were to proceed, we would first look to those students who were frustrated, and their families who were frustrated in their effort to participate, and we would gauge their interest in participating in any sort of revised program. If there were space available, obviously we would consider obviously some sort of a renewed lottery, probably.
So you mentioned the money coming from private sources. Did any of it come from churches that you're aware of?
No.
Did any of it come from outside of Douglas County? There's been talk that maybe other districts might be, if you had won, would be interested in implementing similar programs. Have you had any of that interest?
It is no secret where the funding for our legal fees came from. The principal source, the overwhelming source, in addition to several other foundations, has been the Daniels Fund. The legacy of Bill Daniels is a matter of public record. Bill believed in lots of things, helping scholarships for students that have had challenges in their life afford a higher education. The problems of aging were matters that were dear to his heart, and his legacy of the Daniels Fund funds those efforts. School choice and competition were something that Bill Daniels believed would make our schools better. And so the Daniels Fund has been relentless in supporting what we've done here, and we are enormously grateful for their support. Other foundations have also contributed, other family foundations have also contributed, none with a religious involvement.
Did you ever received any questions from other districts
Oh, we've had inquiries about how to emulate this program from around the country, and we expect that to continue. And in Colorado.
On the note of school quality, your district already has the highest accreditation rating in the state. So why does Douglas County need more choice? Why do you need more competition?
That's a perfect question for a superintendent to answer.
That's a great question. We do have a fantastic school district, one that I believe is one of the best in the state, if not the nation. And it is for that reason that we don't fear the idea that there may be a student who could benefit from another school. And if that's the case, we are very committed to partnering with their parents in whatever way we can to make sure that that child has access to that opportunity. We're going to do everything we can to meet the needs of every single child in our district, but we are not closed-minded to the idea that there might be something beyond what we offer that could be beneficial to that child, and so we want to make sure that we've done all we can to make sure that they're successful.
Considering the Court of Appeals decision versus today's decision, do you have faith that going forward you could be successful in this?
We have reason to believe that the United States Supreme Court justices have an interest in this question. Many justices have spoken publicly about their concern for Blaine and its consistency with our Constitution, our fundamental law at the national level. I will quote Jim Lyons at the oral argument in this case last December, who quoted Justice Thomas, that Blaine is born of bigotry and should be buried. It will take 3 other justices in addition to Justice Thomas to vote for certiorari. 4 is sufficient. We are hopeful that the 4 will see the merits of further review.
Just to be totally clear, it's accurate to say you will take this case, you will try to take this case to the Supreme Court?
We will take this case to the United States Supreme Court following a legal review that has not been completed. Obviously, this decision is hours in the making. It would be irresponsible to predict our next legal moves without having very, very carefully read the court's decision. What we are saying today is, subject to that review and subject to anything in that very, very careful line-by-line review of today's decision that might cause us not to proceed, it is our sense that we will proceed.